The Real Estate Story with Adrian Butera.
Hi everybody, Adrian Butera here, coming to you live from our studio. I'd like to welcome all of you, each and every one of you. Once again, I'm excited and delighted to bring you the real estate story during these COVID times. Awkward, challenging, but I'm glad that you're tuning in and listening here today. Our very special guest today is Russell Cox from Local Lawyers. Russell and I have known each other for many, many years. It's, in fact, beyond 2 decades. He's a prominent local lawyer. He's a prominent real estate property lawyer, and I'm excited to have him along here today. Russell, welcome along.
Thank you, Adrian. Good to be here.
It's great to have you along, and I know this is an awkward time given our COVID-19 lockdowns.
Day one of phase 2.
Day one of phase 2, spot on. Day one of phase 2, stage 3.
Yeah. Who knows what's to come?
Yeah, let's hope there's not another digit or it doesn't carry on there. Russell, I really appreciate you coming along, and I thought as a prominent property lawyer, there's lots of questions our guests may have that we could touch on today.
Well, my book was 1,001 Conveyancing Answers, Adrian, so we'll need to get started.
Not sure that we've got enough time. We try to keep our episodes short and sharp, but let's see how we go. Russell, tell me a little bit about, how long have you been practicing law? Give us some insights into you before we ask the key questions.
It's a long time, Adrian. 45 years. I think I was 5 years old when I was admitted. 45 years is a long time to be in any industry or profession, and in a fairly small niche part of that profession too. I've tended to concentrate on property and conveyancing right through that, with a few iterations on the way through, but that's certainly been my preference and interest.
And tell me, how did you get into, when you started in law, you've seemed to have gone off in the path of property. Was that a natural evolution?
Well, my dad was a real estate agent, Adrian, so it was probably in the genes.
I didn't know that.
Yeah.
Where was he an agent?
At Greenwoods in Footscray.
I think every good principal in the inner west started from there.
They did.
I didn't, though.
Right. I think my dad taught every one of them.
Okay.
Dad would have been 100 next month. Died 4 years ago. And he...
So close.
He was really at Greenwood's teaching man for years. So that was in the blood. Maidstone boy, went to school in Maidstone or Maribyrnong, went to Melbourne Uni, wanted to be a lawyer. Perry Mason, back in the days when Perry Mason was on TV.
Yes.
Started in Footscray with Vince Verducci, and then went to Seckham's. Ian Seckham was a friend of my dad. The first job I got, my dad walked into Vince's office and said, "You've got an article clerk next year, Vince." Vince didn't know anything about it until then. And then Ian Seckham offered me a job, and Seckham's had a good, solid practice in the western suburbs. So I was able to concentrate on the area that, I enjoyed.
So real estate, I should say property, was the direction you followed.
Yep. And
I dare say, you've been around a long time. We've already said that. We've discussed that you've got a long track record in the industry. You've stayed in property, but local lawyers have done other things as well as just property.
Yeah, I had a midlife crisis, as I encourage everybody to do, and I went to the Law Institute, and they wanted somebody to advise lawyers on straightforward conveyancing property issues. So I really was able to drill down into that, and that led me to 1,001 Conveyancing Answers. And so I was...
Was that a book just for conveyancers or anybody?
I sold a lot to the public through the Law Institute bookshop.
Yep.
The guys in there said a lot of people had come in. I always thought it was too much money for... It was $250. I didn't think anybody who's just going to buy a house would want to buy it, but it sold well, and certainly amongst the profession it's the Bible. And then I taught at Deakin University for a while in property, and then 12 years ago, my eldest son graduated as a lawyer, and 2 years after that, his brother. So they're both lawyers, and I wanted to get involved with them, so we went into a couple of practices in the western suburbs, and we've merged 5 practices now because there's nowhere for old guys to go, you know. Sole practitioners.
Acquisitions and mergers.
Yeah, well, be acquired or merged is basically how they go. So, and we've built that into our offices in the Bunnings Park down there, business park. So it's all a different look to the old style suburban practice. People can park out the front and walk in and see a clean desk, you know, something that they're not used to.
Not littered in paper like so many other lawyers.
Yeah. So that's, and I've kept it that with my sons for 12 years, and it continues to grow. I'm not sure how I'll get out of it. I had intended to just work a couple of days a week, but with COVID lockdown, there's not much to do at home, so I
keep working,
drifting back to work.
It's working for me.
Yeah.
Let's just do it.
Yeah.
Now let's talk property a little bit. So, commercial law in property and residential property as well.
Yep.
You do the whole gamut, leases and sales.
Yes. Yep. And if it's got property on it, we're into it.
Now, one of the key topic I wanted to guide us today and see where it takes us is what buyers often come to us and say, mate, can you send me a copy of the Section 32?
Yep.
And then I correct them and say, well, I don't correct them, that sounds terrible. But then I add the words, you mean vendor statement, because I like to call it a vendor statement. That's how I was brought up, a vendor statement under Section 32 of the Act. Yep. I wanted to talk about the vendor statement because it's a critical document with a sale, isn't it?
It is a critical document, but I don't think it should be looked at in isolation, in that I think it should always accompany the contract. You know, you really do have to do your homework through the vendor statement, but you really need to know how does that fit in with the property that's being sold? What are the terms in the contract? More particularly, are there any unusual terms? Now, I was involved at the Law Institute on a committee for about 25 years where we actually wrote the standard contract that the Institute endorsed, and then the REIV endorsed it. So that contract is a fairly equal, fair document that looks after both buyer and seller. And so if you see the contract and it has the general conditions, then as a purchaser you know you're being treated fairly. But if you've got 25 pages of special conditions drawn by the vendor's lawyer, you can be sure they favour the vendor.
Yes, it's a great point.
Just get the vendor's statement. You also should get the contract. And we never let a vendor's statement out naked. We always make sure the contract's there so people can get the whole picture.
I remember back in the day, I say back in the day because I still continue to feel so young, but we used to have contract notes.
I claim a little bit of credit for getting rid of them, Adrian. They were the agent's the agent's cheat sheet, we used to call them. Not fair. There was a standard set of conditions in the Transfer of Land Act which were incorporated into the contract notes. So those conditions applied, but people didn't know that. They just saw a one-sheet document and they thought that was all. But in fact, there was a lot more behind it. So as part of the transparency exercise, which consumer affairs or consumerism is all about, it was decided to put all those conditions into one document and just have the contract.
And I shouldn't confuse anybody. Contract notes are long gone.
Long gone.
We don't need to bring them up again. But Section 32, it's an important document, and as you say, don't dwell on that because it carries often with the contract of sale. But what can you point our listeners to as some pertinent, important points within that document that they should be mindful of?
I always like to consider the law in the context of its history. Where has it come from? Section 32, what's that? Start of the Land Act, what's that? It's consumer protection. The Australian English law always protected the wealthy. It always looked after the landlord, the lender, and the vendor. Over 200 years, those rights of the wealthy have been reduced by consumerism. So in relation to banking, we've got the Consumer Credit Code. Banks get dragged before royal commissions now if they do the wrong thing. So consumer protection strong there. In relation to leasing, we've got the Residential Tenants Act, which is very good protection for residential tenants, and retail tenancy. So they're protected. And the Sale of Land Act is the Consumer Protection Act for purchases of real estate.
So if I could summarise it, just making it more fair.
Yes, absolutely.
Yeah, more fair for all involved, which is great.
The old principle was caveat emptor.
Yes.
Let the buyer beware.
Does that still exist?
Yes, it's still the fundamental rule, but there's a lot of chipping away of that. We haven't yet got to caveat vendor. If we did, we'd have to have a report from a building inspector about everything to do with the property. We'd have to have a survey of the land. We'd need a lot more disclosure to say that we're truly at a caveat vendor position. But it's a lot fairer, a lot more transparent, and a purchaser who is just sensible about things can get a very good understanding of what they're buying.
What about a title? So it's an integral document within the vendor statement.
And that's the biggest step forward with Section 32. The vendor must produce the title. Back in the contract note days and in the pre-1983 days when vendor statements came in, you got a contract, you signed a contract, and then you began a process of checking. And the first thing was to check the title. And that's the first time you've ever seen what you're actually buying. And you'd suddenly find that there's an easement or a covenant or something you weren't expecting. So the big thing about the Section 32 is to bring that forward and put it in the disclosure documents so you could see that.
Yeah, it's certainly important to ensure that you're buying the right property. It's the correct address.
Yep.
It's the measurements
are important.
that have been generally publicised by the agent, but they're at least they're what you believe they are. Certainly, I've known of a few instances in my career where the agents either got it wrong or the vendor got it wrong in some cases.
Yes, yeah. Look, there's been plenty of times that, particularly a block of land down the beach, someone's had it for 20 years, they decide to sell it, and they find out that in fact it's a house next door they own, or more particularly just a vacant block of land instead of a house, So the human error is there, and disclosure hopefully reveals those problems before people get in too deep. And it also reveals planning issues, You want to live in a house, you don't want to buy in an industrial zone. So planning is a big disclosure for Section 32.
What about, so when people do, I've seen a few cases where people have bought a property, it's a house, but it's in an industrial area, and no one thought, and when I say no one thought to check, I'm sure if a lawyer checked it or a conveyancer checked it, it may have been picked up. But I've seen buyers buy properties in industrial areas, and then they've gone, oh, bugger,
well, it's okay
an industrial property.
You're in the house, it's not a problem. If you burn the house down, the house gets burnt down, you mightn't get a permit to rebuild. The council will say, well, no, you're lucky you were there, but we're not going to let you build another house. Now, there are some people that are happy to buy in quasi-industrial areas on the basis that sometimes they turn into a good investment. But you need to know. Yeah. That's what it is. It's information and disclosure.
So, certainly, it's been well aware of that document. Now, I know through, again, my experiences, we've seen contracts of sale that are 100 pages plus thick. Now, when I say contract of sale, yes, you're right, a contract of sale with perhaps 20 pages of special conditions, but the vendor statement is, it's the thickness of a brick.
Yeah. It's the difference between a local lawyer's situation where you generally know your client, know the property, know the area, know what's happening, and a city firm who might be acting for a bank that's selling the property. And they don't know anything about it, only what they can get from public documents. And so they have to get everything. So they might even get for a planning disclosure, not just a certificate saying what the planning is, but they might put the planning scheme in there, which might be, 100 pages.
Right. Okay.
And it's just they're covering their bum.
Yeah.
Because nobody's able to instruct them, no, that doesn't apply.
It's like when we sell a property in the rifle range, they still include the building overlays within that. Still, not all lawyers, but often
Some
see
do,
that.
Yeah, and it's not gambling. It's not taking your luck. It's knowing the area, and if you don't know the area, you do everything that you
Put it
may
all
have
in.
to do.
What's the risk of a vendor statement that only has a copy of the title and a rate certificate? What risks could prevail?
As long as the person who receives it understands what they're getting, that's fine. I've sold a couple of my houses with a one-page vendor statement and the title attached, nothing more. You can put in rates, $1,200, $1,800, whatever the figure is.
Yes.
Zoning, residential. So I used to sort of have a bit of fun with the agent who I might be getting to sell my house and say, all right, here's the 32. And the agent say, where's the information? So my method probably goes a bit too reduction-wise.
Yes, yeah.
But essentially, as long as the title search is there and the planning and rates are addressed, if there's no owner's corporation, you don't need that. There's no GAIC normally, which is to do with development stuff. It can be quite brief.
What about, let's talk briefly about contracts have changed a lot, really, in the last 5 years by way of electronic.
Yeah.
Last night I did an auction that was brought forward and we signed on glass.
Yeah, it's terrific. I've got to say I've been a slow adopter, and my firm, my son's firm, we don't seek to sign documents digitally, but sometimes it comes that way, and I have personally signed some documents digitally, and yeah, look, I think it is it's terrific, and you know, I was around in the early 90s when they were talking about electronic conveyancing. I was on some committees, you know. It seemed to take forever, and I think I got a bit puffed, thought it might never come. But
it's here, isn't it?
It's here, and PEXA is the platform that the settlement actually takes place on. You can have paper contracts or wet signed contracts, or you can have digitally signed contracts. They all push into PEXA at the end. It would be great to have a completely digital platform from contract signing all the way through to settlement. PEXA is really just that last step at the moment.
Not quite there yet.
Not quite there, and old-timers like me are a bit slow to adopt the...
Certainly DocuSign forms a big part of what we do.
Yeah, I think DocuSign has really done very well, and I was marginally dubious about it early on, but I think it works particularly well.
And I must say that I don't have my head fully around PEXA right now. How does that impact the client, the seller, the vendor, or the purchaser?
Well, in terms of the vendor, one great advantage is the money's in your account 20 minutes after settlement. Or that's probably your best, always by the next day. So there's no waiting around for your dough.
Yep.
From a purchaser's point of view, it's a little bit difficult because you would not be entitled to the keys until settlement. And in a paper settlement that's at 12 o'clock in the titles office, it happens, the settlement clerk rings the office, says it's settled, the office contacts the agent, sends them a fax and says it's settled, and theoretically you could get your key at 12:15. So there's, 50, around Melbourne on any Friday, there's 50 furniture vans circling the real estate
So does
agent's
the
office.
settlements office is it still in
No.
existence?
So we've got rid of
Gone.
that, okay?
Yep.
And it now happens electronically. But if there's a hitch, PEXA rolls it over to the next hour, and you're expecting a 12 o'clock settlement, but it doesn't happen. And then it might happen at 1 o'clock, it might happen at 2 o'clock. And the advice to the agent who's holding the key is not yet perfect.
Right.
It's a bit of an add-on that they haven't really fixed up yet. But ideally, PEXA sends an email to the agent's office who's got the key. It says settled, and you could have it at 12:05. Now you send it to the wrong office of the wrong agent, and the wrong franchise or something. It's got some little problem.
Some little glitches.
But that's the only really downside. It does allow for very late changes to figures. So if something's happened with your finance on the day before, you're not rushing around getting bank checks that don't get takes 3 days to get presented and all that.
So it's working well?
I would say
It's working well.
better than I thought it would.
Great.
And it has its problems, but it's a good system.
There you go. Okay. So when I invited you to take part, Russell, you made mention, yep, we'll talk about Section 32 and have a talk about the pros and cons and what to look out for. But you also made mention to me, I wouldn't mind touching on Section 12, material defects.
Yes, as I say, the Sale of Land Act is the Consumer Protection Act for for real estate. Section 9, for instance, is the off-the-plan protection. Section 27 is the protection of deposits. Section 12 has always been a bit of a sleeper, and it says that no person could recklessly or fraudulently pass information to a prospective purchaser about a property. And it's very hard to prove fraud in the law. It's got to be a very, very bad example of dishonesty.
It's got to be obvious, doesn't it?
Very, very much so.
Yes.
1st of March this year, that section was changed to the word knowingly. And the implication is also...
One word does everything.
Oh, huge, yeah. The implication, of course, is should have known, because that's,
yes,
you guys out there, real estate agents,
yes, I know,
might not know, but you should have known. Are you asking the right questions? Now, this section does not give to a purchaser any rights. It's a criminal section, if you like, and it applies particularly to estate agents and to vendors. And it basically says that you have to tell a prospective purchaser everything.
Everything that you know or should know.
Just, yes. Now, you won't know many things if the vendor doesn't tell you.
Oh, we're pretty good though. We know a few things.
Well, you do, but that lovely flock wallpaper on the wall
might be
beside
hiding
the
everything.
chimney might be hiding whatever.
So
right?
true.
You won't know that.
No.
It's not your job to undertake that sort of a physical inspection. The vendor, however, will know it, but it's going to be very hard to prove that. The section has allowed Authorised Consumer Affairs to list the sort of material defects that it says ought to be disclosed. Now, this is a higher obligation than Section 32, which only has 4 or 5 or 6 things. This is quite wide. And if I can just look at my notes.
Please. Please. So this is, while you're looking at your notes, so if a vendor says to me, Adrian, just want to let you know that that extension we didn't get a permit for, but just tell them it was done 10 years ago, I then know.
Yep.
So if the question's then asked, I must pass it on.
You must pass it on, yeah.
Great.
And that indeed is one of the examples. Building work or other work done without a required building permit, planning permit, or that is otherwise illegal.
I could foresee you saying that, Russell. That's why I said that,
Yeah,
and because no one's ever said that to me before.
So this is going to get pretty tricky.
Mm.
One of the things is a recent homicide in the property.
Has that not been around for a while?
In New South Wales, there was a case about 10 years ago.
Yep.
It's never allowed a purchaser to avoid, and it doesn't here either, but it does create an obligation on the agent. Or if the property's been used as a meth lab.
Okay, there you go. Does that apply to commercial as well?
Yeah, commercial real estate.
Yeah, okay. That's interesting. I can let you know that many, many years ago, I was involved in selling a property, what was known then as the Vampires Murders House. I did. I sold the property. And it was, we didn't have to disclose it, but believe you me, we did.
Yes, yeah. And didn't sell. Yeah, eventually.
It sold. Yeah, it sold.
So if there's an obvious physical defect, so that'd be the crack in the wall.
Yep.
History of pesticide use, so here we're pushing into agricultural type areas.
So that's interesting. So I've got a vegetable garden at home and I treat it with, let's say, snail bait.
Yeah.
I don't, but if I did,
I think that's probably to the lower end. Of
Right.
It's
Okay.
snails are probably not what we're looking at.
Right.
Yeah. It goes to hazardous materials. So it says a defence or fire brigade training area. So this is that PPSR or whatever that very dangerous chemical is. They want any use of that on the property disclosed. Facts about the neighbourhood surrounding the property, which may not be immediately apparent upon inspection.
So is that like me getting asked at an auctioneering competition some years ago, and one of the buyers said, "Excuse me, Mr. Auctioneer, I noticed there's a pair of runners tied in a knot flipped around the power lines."
Yeah.
Does that mean that
it's a drug house?
Yeah.
Yeah.
And you know, I can't remember what my answer was.
I'm
but
sure it was good.
It was. I gave it a crack. Excuse the pun.
Yes. The common one here is there's always been an obligation to disclose permits on your property, right? But never outside your property or not so sure outside your property. But what if you're buying a property and next door's got a permit for a 5-storey apartment block?
So does that get disclosed now?
It probably does.
Okay.
Or more particularly, the failure by the vendor or the agent to disclose it is an offence against the Act.
So that's really interesting, because I've acted for many people over the years, and I expect I will continue to, where there's just 2 properties, and next door applies for 3 or 4 townhouses, and the owner next door to that,
Who I'm
selling for, they say, actually, I don't want to live next to 3 or 4 townhouses, so they put it on the market immediately when the application is in the early stages. So no permit approved.
No approved, that's it.
So there's going to be, you know, what do you say?
Yeah. You don't want to know for a start. And in the past, you would always say, look, you need to make your own inquiries. That's not part of my job. But this is a bit of changing the goalposts here a bit, for estate agents particularly. And the REIV has produced a 3-page form that suggests you give to your vendors, and what colour are your socks, and did you wash your undies this morning? And it really is very, very intense.
I think it's important that we do convey everything we know, and I it's funny when you brought up material facts, and I was scratching my head when you said section 12, but the content of it I know very well. Didn't relate it back to that section number, but it's important that if the information is held by the agent to convey that to the prospective buyer in all instances.
Can I go the other way though?
Please.
Who's paying your commission?
Vendor.
Whose interests ought to you be protecting?
Well,
I don't want you to tell them, Adrian.
There's 2 pieces of bread in a sandwich. You need both pieces to have a complete sandwich.
I like that one. That's good. Yes.
We might be the meat in the middle, or the piece of lettuce for all our vegetarians out there. But at the end of the day, we do need to complete that. To affect the sale, both parties need to be happy.
Yeah. The worrying thing is that you'll be telling vendors that this is what they need to disclose, and they'll fish around and they'll find a less reputable real estate agent who won't ask them those questions, and they'll think, well, that's where I'm going.
I'd like to think that most agents are very reputable. It's a pretty good industry. The select few, Russell.
Yeah. We live in interesting times in this regard, Adrian.
We do. Interesting times. Let me ask, let's move on from section 32 for just a moment. Buyers out there often ask me, Adrian, can you recommend a lawyer, a conveyancer? By the way, what's the difference? What is the difference between lawyer and conveyancer?
Well, only competence, Adrian.
Oh. Goodness. Sorry, apologies for all the conveyancers listening.
Yes. Lawyers have a wider view of the consequences of any transaction. They'll know tax implications, GST, CGT. They'll know inheritance type, succession law. How's this going to play out in that regard? And they will just be, I would suggest, more careful because they see the problems earlier potential problems are identified and don't become problems. I know a lot of conveyancers. I know some conveyancers who are very competent, but I know a lot who try to do things they shouldn't be doing.
So for those that are going to, let's say they're on the fence, let's say they're going to use a conveyancer, how do you choose a conveyancer? Do you just do it on fee? How would you make that decision if you were hedging your bets and you say conveyancer A, conveyancer B? How would you pick one? And I'm going to ask the same about a lawyer. How do you pick one?
I suppose I'd say the same about an estate agent. People come along and say, going to sell mum's house, and I'll say, well, go and see 3 agents, get an estimate from them. Don't necessarily take the highest estimate because they're just trying to buy your job. Identify the relationship that you think you have with that agent and run with that, because that's the best way. If you simply ring up an agent and say, how much is your commission, you're wasting your time. Same with lawyers and same with conveyancers. If you're just going to be guided on a transaction like this on the basis of $100, you're not doing yourself justice. So
we certainly say people like to do business with people that they like and trust.
Yeah, and this is a big transaction. So I think recommendation has to be the way to go. You need...
Most definitely. And I think it's also important to consider that at a simple view, just transacting the sale, that can be fairly simple.
Yep.
But if something went wrong, who do you want on your side?
We get a lot of people come to us after the conveyancer can't fix it. And we used to take the view of, bugger, we don't want your work. But now we sort of have a different view that, look, it's a different market. These people have made a mistake. Let's help them out of it.
Yeah, I think really, really important to think about that. Who do you want on your side when things haven't gone quite right? Yep. Russell, we're almost to the end of our episode, and I'm really delighted. You've really summed up some important points there in section 32 and material defects in section 12, which is great. And some may say they're dry subjects. Well, they're only dry if you're not into property right now, because if you're into a property, they're absolutely key. They're absolutely critical. What I want to ask before you leave us, how's COVID-19 affected local lawyers?
I would say that there was probably a 20% drop in March 2025. Probably 10 to 15% drop still, but it has produced a lot of issues in the leasing market. We do a lot of commercial leasing, mainly for landlords, and there's a lot of tenants out there who are struggling and they're asking for rent reductions, and a lot of landlords saying, well, why does this fall on me? Well, you can go to your bank and get some help out there, but no, this is my clear title and this is my income, and it's now 25% less than it was, and I can't sort of send a chit into the federal government to get that. So it has caused some landlords some problems, but equally at the coalface, tenants are really struggling, and I reckon there's 20% of tenants won't get through, particularly after this relapse today.
Yeah, it's been frightening to just see. If I can say, is one thing I've learned as an auctioneer is just to read people's faces. I think it's really hurt people this second time round. Yeah. For those listening to this episode in months or years to come, I wonder how they'll reflect and how it ends up. But right now, there's a lot of pain on people's faces. Which is going to lead me to give us a quick snapshot. You've told us a little bit about local lawyers. Quick snapshot on your business. I know David, Andrew, your 2 sons are with you. Commercial law, property law.
Very much a general practice, a mum and dad practice, and we've taken over mum and dad practices, So we hold lots of people's wills. We do lots of wills on a regular basis. We have a lot of residential conveyancing, and that has developed into local business people, builders. We act for them, and Andrew in particular has built a large leasing practice. In fact, we're just looking to put another lawyer on, even though there's been some reductions. That particular area is really bounding along.
Wonderful.
So it is rewarding, but it'd be nice to have a bit of a break.
Maybe a holiday soon, post-COVID holiday.
Yes.
Russell Cox, thank you so much for joining us. Russell Cox from Local Lawyers, everybody. Thanks, Russell.
Thank you, Adrian.
Have you used the Keep Me Posted button on our website? Just click Keep Me Posted and fill in your requirements, and you'll automatically receive all our up-to-date listings as they appear.
Well, there you have it, everybody. Normally I rattle off a story, but this week it's going to be really short and sweet. And I'm going to just reflect on 25 odd years ago when I first met Russell. Russell and I used to do the home buyer seminars that were supported by the state government at the time. Russell was there for the Law Institute. I was there for the REIV. And we used to provide insights into the property market, buying real estate, and there was the RACV were there and insurance bodies, and there was a whole gamut of people that would present over a couple of hours. It was delightful to be able to share our knowledge and experience, to allow others to take that away wherever they were buying, selling, whatever they were doing in real estate across Victoria. We gave them a quick insight into the property market and what they should look out for and what they should plan for. And also, I thought as you were going through, Russell, I thought of another story. Is Joe Borovecchio still at the Law Institute?
Baravecchio.
Baravecchio.
Left the Institute, I'd say, 5 to 6 years ago. Joe, he acted for the Institute when they were chasing bad lawyers, people who'd done the wrong thing. And Joe would chase them down, and once Joe was on your tail, you didn't have much hope.
Well, I thought it was good when you brought up the Law Institute. It was important I point out he taught me law 30 years ago.
Oh, wow.
Yeah, at RMIT in Franklin Street.
Yep.
I think it's a block of apartments now. Ladies and gentlemen, thanks for joining us on The Real Estate Story. We'll see you next week.
The Real Estate Story brought to you by Compton Green.